This video is about the probate application process, and probably not the most interesting topic in estate law out there, but probably one of the most important, because in almost every single estate that we come across, the executor is going to have to apply for probate. So before I get into the application process, it's important to remember that being an executor means that you have complete authority over the deceased person's property and assets. And that power to essentially step in their shoes and control of all of their property, the power comes from the will itself. And so if you're named as an executor in a will, you, because your name is in there, have the power to take control of the deceased person's property. The problem, though, is that financial institutions, the Land Title Office, and other third parties will not let you deal in any way with the assets unless you get what we call a grant of probate. So it's a very, very important step in the estate administration procedure. And so what a grant of probate is, it's a declaration from the court, essentially, that the will that you're relying on and that you're submitting to the court, it's a declaration that that will is valid and that your appointment as executor is valid. And that is what these third-party institutions insist on, because they want an assurance that this is a valid document and that you do, in fact, have the authority to be dealing with what can be a significant number of assets. So the actual process then for applying for probate is, it can be a technical one, but it's a very standard one, and overall it probably takes a few months. So the very first step in the application process is for the executor to provide notice to all the beneficiaries of the estate and to all the to any other family members of the deceased person, essentially who aren't named in the will, if they're not named in the will. And you have to give this notice 21 days before you're allowed to actually submit your application for probate. And the reason for that is it gives the beneficiaries and the other family members notice that of who's applying for probate, and it also gives them time to raise any concerns and to file any challenges to that if they want. But assuming that 21 days goes by, then the executor can actually make an application to court for probate. That application itself it's a variety of different forms. There's an application form. There's some other kind of technical forms that are filled out. But it also but the executor also swears a few affidavits setting out information about the estate. And the most important affidavit is what is called the affidavit of assets and liabilities. And so by this stage in the process of being executor, the executor has already investigated and gathered in all of the deceased person's assets. So they should know by this time what exactly the person had and what debts that they owed. So the executor then swears an affidavit saying that they've made a search for the assets, and they set out for the court exactly what the deceased person owned, and also what they owed, so their assets and their liabilities. And the reason that's very important is because in order to get a grant of probate, the executor has to pay probate fees of approximately 1.4% of the value of the estate. Now, of course, that money comes from the estate itself, but that has to be paid before the grant is issued. And so they use that affidavit of assets and liabilities to calculate that 1.4%. So once everything's submitted, what happens is it usually takes anywhere between about 4 to 12 weeks for the court to issue an estate grant or a grant of probate. And that really just depends on how busy they are at any given time, what location you're applying at. And then essentially what happens is a couple days before the court is ready to issue the grant, they will let the executor know how much is owing in probate fees. And then the executor pays it, and then a couple days later they'll have their grant. And once the executor has that grant, then the executor has complete authority to go to any institution, so banks, other financial institutions, the Land Title Office, and they can rely on that grant, and they can then deal freely with the deceased person's assets. sell them, transfer them, whatever they're supposed to be doing based on what the will says. So I hope this video has been informative. Subscribe below if you like what you see, and I will see you in the next video.